Hi, everybody, and welcome back, everybody. It was really great to start the conference this morning with such a high level of participation. So I'm hoping that we'll continue with that in this next session. So now we're going to start with the second academic session of the conference, and this one is running from now until 2:30. It also covers COVID-19 and competition enforcement. And again, we've sifted through many submissions to get to these ones, and we've selected those that are of the highest quality on this topic. So before I introduce our moderator, let me share again how you can participate in this session. You can write your questions in the Q&A function. It should be at the bottom of your screen on this platform, and we'll do our best to get to them. So let me turn to our moderator now. Our moderator and discussant for this session made a cameo appearance in the first one if you were watching. She is Pamela Mondliwa, and she will introduce the panelists and the papers for the discussion. Pamela is well known to everybody in competition. She's a senior managing consultant at Berkeley Research Group. She's also a research associate at the Center for Competition Regulation and Economic Development. Pamela, can I turn to you now?
Good afternoon, everyone, and welcome back. I'm glad that the numbers are looking good after lunch. You don't always get this. So today we have a really great session that we're in for a treat in terms of the kind of discussion that we're going to see emerging from the session this afternoon. And I'm really looking forward to the discussion and the engagement that we'll have on the papers. We have three papers that will be presented. And on the panel, we have Dankiso Tibane, who's an economist in the Economic Research Bureau of the Competition Commission of South Africa. We also have Nonkululeko Moketsi, senior analyst, also at the Competition Commission, and Barang Kienzad, I hope I said that correctly, PhD fellow in the Faculty of Law at Copenhagen University. I think a warm welcome to our panelists, and it's really good to see the Commission is also taking the time to reflect on the issues that they've been dealing with through this COVID period. Nandi has already mentioned earlier around, we'd like to maximize as much participation and take on your questions later on as we do engage with the speakers. So please do share your questions, and Rahma will be assisting me in terms of managing the Q&A for the afternoon. So I think we should start so that we can really hear what the speakers have to say and then engage with them properly afterwards. I know I have not given long introductions of the panelists, but please do look in the chat function where Rahma has pasted in their more detailed bios so you can get a better sense of where they come from and what they have done. So without further ado, I think let's start with Dankiso, who's going to present on the interface between public procurement and competition regulation during COVID-19 pandemic, and she's providing a South African perspective on that. Dankiso.
Okay, thank you, Pamela. Just trying to switch on my video. Okay.
My apologies, Dankiso. I said she. All the Dankisos I know are female.
No, it's fine.
Apologies for that.
So
okay.
I'm just gonna share my screen. I hope everybody can see the screen, the presentation on the screen. Okay, so as Pamela has said, I'll be presenting on the interface between competition regulation and public procurement, focusing on the South African perspective. So I'm joined by my colleagues, Sipho Shumani, as well as Songezo in the panel. So this is the presentation outline, but in the interest of time, I'll just go straight into it. So the paper had 4 objectives. Firstly, to establish the interface between public procurement and competition regulation, as well as understand the role that competition authorities have played in addressing some of the competition concerns in public procurement. We also looked at the public procurement regulatory framework, as well as assess its effectiveness during the COVID-19 pandemic. The relationship between the two phenomena, we find that competition principles are key to the formulation of any public procurement regime, in that this can yield positive results as efficiency as well as savings. Public procurement can also be susceptible to anti-competitive behavior. This is because of the sheer volume of and financial value of public projects, which make the process vulnerable to abuse. Because procuring institutions are constrained by the regulations when conducting procurement. So these conditions, when you look at them holistically, they tend to confer some level of market power on market participants when doing business with government. So competition in public procurement is important in that it can lead to competitive pricings as well as quality. So the competition authorities have played an important role in the public procurement process, more especially in addressing some of the competition concerns that have come from this from public procurement, and we find that the concerns are largely the same that can occur in an ordinary market context. This can be bid rigging, price fixing, collusion, and more recently with the COVID-19 pandemic, we're seeing a lot of excessive pricing cases. The procurement process can also harm competition, more especially where the tender requirements are needlessly too broad or technical for SMEs to participate. Over and above the concerns that arise from the conduct of market players, we also observe that the nature or the manner in which government enters into contracts with the private sector can also result in anti-competitive effects. For example, transversal contracts where they can entrench dominance of a particular player in the market. Some of the concerns that we have seen in public procurement have been during this time of the pandemic, like I explained earlier, that there has been complaints around excessive pricing, and the Commission has prosecuted some of the firms and concluded settlement agreements in this regard. So the public procurement process in South Africa is governed by various pieces of legislation, with the Constitution being the overarching piece of legislation. And looking at emergency procurement, there are several sections of the Disaster Management Act which makes provisions for emergency procedures that can be followed in procurement. And these are the only sections of the Disaster Management Act that bear significance to public procurement. And also to mention that, the National Treasury has issued instruction notes as well as provincial treasuries to provide guidance during this period. And lastly, market participants are expected to behave in a manner that does not fall foul of the Competition Act. So the Treasury, as explained, introduced the instruction notes which guided procurement during COVID-19, and some of the Commission concerns were that procuring institutions were supposed to procure some of the PPE items from suppliers who were in the government central supplier database. So the concern was that this foreclosed other market players who were not in the database. And the other concern was in relation to the PPE specification, that they were too specific and excluded other market players who did not meet the exact product specifications. The Treasury also included a price list indicating the prices at which government institutions are willing to pay for PPE items. And from a Commission perspective, any form of price regulation or control can have unintended consequences in that, it can exacerbate the shortages that we have seen, of PPE items around the globe. And I mean, economic theory on competition and regulation also implies that competition is supposed to lead to lower prices. So we are of the view that open competition can lead to to competitive prices in the market. The Commission's price gouging work also shows anti-competitive conduct during the pandemic. For example, the Commission had received about 50 complaints related to public procurement, and these were largely excessive pricing complaints, which came from the South African Police Service as well as the National Health Laboratory Service. These complaints were against 3 firms, which the Commission referred to the Tribunal for Adjudication. For example, the Commission found that these players had earned gross markups which were rendered excessive. However, the Commission, the Tribunal has not yet made a decision on these cases, but it will be interesting to see the outcome. So in terms of the effectiveness of the COVID-19 procurement regulations, we find that there's evidence that procuring institutions have paid more than 5 times the recommended 5 times the recommended prices by Treasury in its instruction notes for PPE. And this has shown the ineffectiveness of these regulations that have been issued by Treasury, in that, in as much as, there was some guidance in terms of what government institutions had to pay, but that was exceeded. And I think one of the recurring theme in the COVID-19 public procurement process has been corruption, and this has been seen in the preliminary findings of the SIU and the Auditor General, where it found non-compliance and deficiencies in the system, where PPEs have been acquired at prices that are excessive. And this has sort of exposed the weak regulatory environment that we find ourselves in terms of procurement. The draft public procurement bill also makes provisions for emergency public procurement, but it does not go into detail in terms of how this should unfold. So we are of the view that it falls short in providing guidance to state institutions, as it relies on the regulations that are issued by the Minister of Finance. So in conclusion, we find that the public procurement process has been at the forefront of fighting the pandemic, as the acquisition of essential COVID-19 equipment has been done through public procurement. The easing of public procurement regulations has also opened floodgates for abuse. This has taken place in the form of corruption or anti-competitive behavior. And this ineffectiveness might have been caused by the lack of understanding or having regard to competition principles, because immediately when competition was stripped away from the public procurement process, we found that there was abuse that took place. There are several aspects of the procurement process that needs to be improved to ensure better monitoring and oversight, as well as to follow a value-based approach rather than just a price-based approach. Public procurement presents an opportunity, for the state to use its bargaining power in terms of promoting the social and policy objectives, such as ensuring that there's increased participation of SMEs in the market, because public procurement forms a large part of government expenditure, as well as the GDP. So the state can use its bargaining power to achieve some of the policy objectives. Going forward, coordination between public procurement and competition authorities is going to be important, given the relationship between public procurement and competition regulation. And the public procurement draft bill also proposes the public procurement regulator whose mandate intersects with that of the commission. So there has to be some cooperation framework between how the concurrent jurisdiction will be managed between these institutions. And with the draft public procurement bill, we're of the view that there's some silver lining. It is a positive step in the right direction to address some of the challenges faced by the state in procurement and in contracting with the private sector. That concludes my presentation.
Thank you, sir. I think that was really great in terms of laying ground on the experience that South Africa has had with regards to public procurement, and really bringing into the foresight again, I guess, long-standing debates in South Africa around the interaction between competition and corruption. Before we move on to the next speaker, something I'd like you to think about that I'd like to pick up later on in the discussion is how can procurement both promote competition, preserve productive capacity in particular, as well as promote Black economic empowerment objectives and other policy objectives. But that's something that we'll pick up later on when we reach the discussion. Our second speaker is Nongulego Mokete, who's going to give us a presentation about excessive pricing in the time of COVID-19, insights from a regulator's perspective. Nongulego.
Thanks, Pam, and good day, everyone. I'd just firstly like to preface this presentation by saying that it is in our own personal capacities as the authors of this paper and this presentation, and that the views expressed today do not necessarily reflect the views of the Competition Commission. With that said, the purpose of our paper was, as you said, Pam, to provide insights into the Commission's approach in its intervention in markets of essential goods and services that are needed to cope with the outbreak of the COVID-19 pandemic. Our paper did not seek to discuss the merits of the cases that have been brought before the courts, and it did not delve deeply into the legal or the economic arguments that were presented. Next, I'd just like to provide context for why we did intervene as the Commission. So as we know, on the 5th of March, 2020, South Africa confirmed its first positive case of COVID-19, which was followed by the declaration of a national state of disaster on the 15th of March. On the 19th of March, the Consumer and Customer Protection Regulations and Directions were published in part to protect customers and consumers against unjust, unfair, and improper commercial practices. During this period, there was a huge public outcry about the sudden and sharp increase in prices of essential goods such as hand sanitizer, face masks, gloves, and toilet paper. The proof of this can be found in newspaper clippings or newspaper articles, as well as on social media. So if you go on Twitter and you search for the Commission's Twitter handle at ComComSA and put in phrases such as price increase or price gouging, you'll be met with many tweets of customers and consumers and the public at large basically complaining about the increase in prices of these important and essential products. So by the 27th of March, 2020, the Commission had already received almost 400 complaints of price gouging. And by the end of April, the Commission had received more than 1,000 complaints. So the public sentiment around the pricing of essential goods and services really called for timely and effective enforcement by the competition authorities. The competition authorities are mandated by the Act to protect and safeguard the interests of consumers and the public at large. And this specific mandate is located in the preamble and the purpose of the Act. So on the 3rd of April, 2020, the Minister of Trade, Industry and Competition published regulations which contained rules in which complaint referrals could be brought to the tribunal against alleged excessive pricing or price gouging under Section 81A of the Act. And indeed, in Babelehi and in Dis-Chem, the Commission did seek an order that these matters be heard on an urgent and expedited basis. And the tribunal in both cases concurred with the Commission to say that, at least in the public interest and in the time and the context that we're faced with, COVID-19, it was very necessary that these matters be investigated and considered on an urgent basis. Next, I'm just going to provide a brief summary of the Commission's track record and experience in investigating and prosecuting abuse of dominance cases. The reason that I do this is basically to just justify or put in context why the Commission had to depart from this traditional way of investigating and prosecuting excessive pricing cases. So in the 20 years that the Commission and the Tribunal has been involved in competition regulation, there have been a few cases that have been successful, at least at the Tribunal. Of the 22 cases, pardon me, that were referred to the Tribunal, only 6 cases were successfully prosecuted and attracted substantial penalties. A further 6 cases were settled. The rest, unfortunately, were dismissed. The reason for this low level of enforcement can be attributed to the complex nature that abuse of dominance cases are. And because abuse of dominance cases involve lengthy and costly legal proceedings. Excessive pricing cases in particular are quite complex to investigate and successfully prosecute. And to date, we've only really had 2, and that being Mittal and Cecil. So a typical case, abuse of dominance case that would come to the Commission would be investigated in 18 months. And after it's been referred to the Tribunal, it can take between 2 or 5 years or even longer for that case to be finally heard at the Tribunal. So to give you some practical examples, CompuTicket 1 was referred to the Tribunal in 2010, but the case was only heard at the Tribunal in 2017. So between the time that it was referred to the Tribunal and for the case to be decided on, it took 9 years. In contrast, Uniplate was referred to the Tribunal in 2015. The hearing took place in 2017, and the final decision was released this year. So in total, it took 5 years. So in the context of a crisis or a national state of disaster, we really have to ask ourselves if it's really appropriate and in the public interest for the competition authorities to dedicate significant resources and time into investigating and prosecuting excessive pricing cases. Or do we need to think differently and perhaps think of a new and different approach to these cases? So since the Commission announced that it would be considering price gouging cases from March already, there was criticism that was leveled against the Commission for what is perceived to be an aggressive or a heavy-handed approach, especially towards small and medium enterprises, which typically would not be found to be dominant and who play in markets which typically do not exhibit the structural features that should compel intervention or cause alarm. There's also been questions around, firstly, the urgency to firstly investigate these cases, but also secondly, to finalize them on shortened and strict timeframes. We are of the view that during these unprecedented times, it's very important that competition authorities intervene in a timely and impactful manner because consumers are most vulnerable and choices are quite limited. And we are of the view that without the Commission's intervention, consumers are likely to have been worse off. Even though there's criticism that the Commission was a little bit aggressive, we are of the view that throughout the world, other jurisdictions have actually adopted a similar approach to South Africa. I think it was very important for all the competition authorities and jurisdictions to send out a very stern warning and a very strict message to the market to say that price gouging, particularly the pandemic, is a very grave and reprehensible act. So in conclusion, we are of the view that the traditional way of assessing, investigating, and prosecuting excessive pricing cases would have harmed consumers, and the availability and reasonable pricing, especially of essential goods and services during a pandemic, is very critical. The Commission's interventions will still need to be properly evaluated at a later stage to really quantify and determine the savings to consumers and the economy at large. And we are of the view that impact assessments and ex post reviews will be very instructive in this regard. Thank you.
Thank you very much, Nguleka. I think this is probably the one topic that everyone's been interested in and really obsessing over in the last few months. So thank you for providing the reflections from your perspective, not necessarily the Commission's. And there are many questions that I'd like to ask of you, so we can really try to understand what this means for competition, for excessive pricing enforcement going forward, and whether there are any insights from the COVID cases that can now be taken on to standard excessive pricing cases. But for now, I think let's start by hearing Barang's presentation, who's actually also on excessive pricing. His presentation is titled "The Giant Awakens: Law and Economics of Excessive Pricing and COVID-19 Crisis." Barang?
Hi, can you hear me? Great. I hope everybody can hear and see me fine. First of all, thank you very much for being invited and included in the program. And as said, I have the dubious honor of dedicating my PhD thesis to the subject of excessive pricing, which is, as you have heard, is a rather complex subject spanning over multiple disciplines. And I'm coming a bit towards the close of it. The paper I've submitted is a quite heavy one. It spans over 50 pages in total, so we're not going to be able to cover that. What I will be able to cover for you in this session is the empirical inquiry, which I did for this matter. I just try to see if I can share the slides with you briefly. And there you go. Can you see that, everybody? Okay.
Yes, we can. Go ahead. Please put it on presentation mode so everyone can see.
Oh, there you go. All right, great. Okay, so basically what I've done is that I've been researching the subject for a couple of years now, and have done a couple of papers on that. Most of it is forthcoming, but due to the thesis not being able to be published before it's handed in. So, but I try to give you whatever I can from it. So we had naturally we've seen a lot of excessive price cases also in Europe. The reports we could also note in the media, social media, as was also mentioned. And I took the initiative to send out an empirical inquiry to all competition authorities around EU. So I'm going to walk you through that, and after that I'm just going to offer you some brief analysis of what was coming as the answers that we received, and I will just finish with some law and economics conclusions on that note, with a very brief notes on the South African cases which I have read and analyzed in the paper. Okay, so excessive pricing generally, as heard before, is a rather complex theme. The problem is that it's on the normative side, it's quite complex, because you have some issues such as dominance. How can you define dominance? What is market power? Will prices be self-correcting or not? What is the role of the competition authority vis-a-vis a regulatory authority, or the sector regulator even, and so on? And what is a fair profit, which is the holy grail, so to speak, in the kind of research that we do. And further, there are also some empirical issues to conflate the matter further. Assessment challenges: how do you assess? What kind of benchmarks you're going to use? Does this enforcement, even if done according to correct normative and correct empirical benchmarks, does it risk chilling investments, and so on? And what kind of competence the competition authority has or should have is all matters of debate in the main papers that you find. Then we had the pandemic, a global crisis. And normally during a crisis, naturally prices surge because of the surge in demand. This is not a strange occurrence. However, does it change the dynamics, or should it change the dynamics? But we could see ipso facto a surge of excessive pricing and price gouging cases globally, despite the warnings which were also aforementioned. Some core assumptions of the economics theory, because economic theory is not monolithic. There's a host of different types of economic theory, although it's sometimes presented as mainstream or common wisdom or such phrases which are not really all-encompassing of the complexity of economics. However, the certain strands of economics, such as the welfare school, neoclassical school, marginalist school, the normative and empirical issues when they object to excessive pricing should be revisited, and this has been done by others. I just quoted names of some Nobel laureates. I'm from Sweden, so we have a keen on Nobel Prizes. And although I myself approach it from a Kantian and a Keynesian approach, I juxtapose it to the utilitarian and welfarist approach regarding the object of competition law and political economy in general. The legal framework is Article 102, Treaty on the Functioning of the European Union, and the test that we use is the United Brands test, where they developed a two-step test. And the jury is out if it's cumulative or not. And basically, first you look at if the price is excessive in and out of itself or compared to other metrics. And then on the second stage, you check if that excessiveness is also unfair. So about the survey, it was done by email. I sent the email to all the official emails of the competition authorities around the EU. And then I followed up by email, by telephone, and those who had not gotten in with the answer yet. 3 questions were posed. How many excessive price complaints or cases have your authority received? If your authority already has opened any proceedings, or if your authority intend to do so. And if they have any other general comments about excessive pricing and stating their general positions. And as you can understand, due to the because EU is comprised of many different countries, and they have all their competition laws. Although EU competition law applies throughout, the confidentiality rules and so prevented some of the authorities to answer. But I give you whatever we could receive. So the response rate was quite good. We had, out of 27 countries, we had the answers from 23, with 4 countries abstaining or not giving an answer, Greece, Hungary, Romania, and Slovakia. And here you can see on table 1, you can see the category A, and there are cases received from 500 up to 9,000 and plus. UK is on the top there, as you can see, Poland, 2,600 cases, and Spain. Italy and France, they are not included. Italy has received a lot of complaints. They could not provide an exact number. That's why they are in the footnotes. Another category, category B, it was countries receiving, I should just, let me give you 1 second. That one seems not to be here. I give you this one instead. So you can see that. Pardon me for that. Terribly sorry. There you go. So, and the category B is countries receiving between 1 to 10. And we could note Germany with 3 cases, Denmark 3 cases, Belgium also 3, and Austria with 10 cases. So it's a rather marginal note there. We had also some other countries. They just said that they had received some. And here are the investigations pursued. Belgium won, Spain some. They could not provide an exact data because of confidentiality rules. Same with Poland. United Kingdom 4 cases, and Italy some of the same reasons. And subsequently, UK had closed, opened, investigated, and closed 4 investigations, not finding an infringement. Here you can see a slide about the maximum pricing being introduced in some countries. Malta, Croatia, France, and Romania also, but Romania was not included. I had that from the OECD data. And here is a graph provided to me from France, where you can see the prices when the price was introduced, the pricing rule, the prices subsequently dropped, as you can see. Now to some general responses received. Well, basically, most authorities, they reaffirm their position that they will pursue excessive price casing as a statutory duty. However, they also, as you can see in the response of Germany, as an economic rule, the shift in demand typically leads to higher prices. However, as we shall see, if we further, these higher prices must be investigated, whether it is depending on the cost and the supplies, or it is just price gouging per se. And also another important issue is the dominant position, because this is mandatory in EU law. However, dominance can be construed alongside of temporary dominance, as per the ABG oil case in the 70s. And there are also some guidance by the Commission and OECD also in how you can construe dominance in crisis or in temporary positions. Spain and Portugal received complaints. They had made some investigations, but they didn't find an abuse as of the dates where they submitted their responses. Italy is one of the most active jurisdictions, and they are pursuing multiple cases as we speak. France, a bit of institutional divide there between the competition authority and an authority they have for finance and consumer protection. I will recapitulate this when we get to the analysis. Sweden did a study because there was a report of 900% spike in prices to the public procurement body, which buys the material and supplies the municipalities and regions. However, they could see that the prices had subsequently dropped, so they did not pursue the cases further. This was also the case in United Kingdom, generally speaking. They had also targeted some online platforms. This was also the case in Italy. The sectors affected, you can see that it's basically the same in South Africa and also in US and so on. It's hand sanitizers, disinfectants, PPEs, face masks, food sector, financial sector, but also funeral services. This was the case of Greece. Well, basically, what we can see, the contours of the problem is that you could note sharp price increases in essential items, and this was done in the beginning of the crisis, in March, April, February, partly, and after that, the prices kind of decreased. There's a manifest difference in the approach between US and EU and South Africa. US and South Africa, they had introduced laws which prohibited against a heavy spike in price compared to the pre-crisis. This was not really done in EU. So we don't have those kind of regulations to rely on. We just have the maximum pricing, but this is not a competition law tool or help in these cases. And as said, they reaffirmed the commitment to pursue the cases as a matter of statutory duty and anti-competitive practice. However, some authorities seem to consider excessive pricing outside of the remit of competition law and defer to a free market dynamics. As said, some price regulations were introduced. However, some countries pursue these cases under the consumer protection law or unfair pricing law, and they combine the Consumer Protection Agency and the Competition Agency. This is the case in UK and Italy and Poland, for example. And those are actually the countries where they also received the highest number. So there's a correlation. I don't know if it's causation, but it's a correlation. Dominance and market shares, it's a very big issue. It's a main issue in this kind of cases. In EU, this is not the case in US and South Africa, not to the same extent. A local shop can be found liable, although they don't have any higher margins or market shares.
Sorry, Varang, we've run out of your time and we are keen to get to the discussion. Please wrap up your next slides quite
Sure,
quickly.
this is the last slide.
Thank you.
I'm done in 1 minute. So dominance and market share, as said, an issue in EU, not per se in EU, South Africa. South Africa does put the emphasis on unconscionable and unfair price increases and of these practices. The courts in EU should be noted, and the authorities, they have not shown themselves particularly receptive to the rather blunt criticism of the judgments in the doctrine. And so we have had a host of excessive price cases in the EU in the past years in the pharmaceutical sector, and they have all been upheld on appeal. And to conclusions, well, it is excessive pricing is, as I see it, is a very much underdeveloped and developing concept in law and competition law economics. As I also mentioned before, the new classical and marginal schools, they're not really well suited for this kind of analysis of dynamic competition on fairness and crisis. They don't have the necessary tools, in neither normatively nor empirically. And although there are a host of metrics to be employed, cost plus, spatiotemporal comparisons, profits pre-entry and pre-crisis prices, and so on, there's always a value judgment to be struck. And this cannot be construed along static economic analysis. But you can use behavioral economics to reach better solutions. Also, there are now statistical and algorithmical approaches. And furthermore, the majority of neoclassical objections against excessive pricing, they do not really hold in a crisis situation and captured markets and so on. And although complexities and challenges should not be underestimated in this case, nor should the deterrence effect and the importance of competition law to deal with excessive pricing and unfair pricing. And excessive prices, there are few, but they are not that few. They are well on par with predatory and margin squeeze cases globally. And I think the dominance by a certain strand of economics over competition law has contributed to this reluctance, supposed reluctance. And so there's also a risk of conflicted approach where consumer protection is sorted under competition law. And it is also important to delineate between regulatory approaches of being of importance, especially during a crisis. Thank you very much.
Thank you very much, Varang. That was very interesting. And I think it's a nice way of balancing Nonkulego's presentation, which was very specific about South Africa. So it's good to be able to see that the issues that we are engaging with as the competition community aren't unique to South Africa, but countries all over the world are really grappling with these issues. So I really liked that you reflected on what other countries are doing. I think now we can move on to the discussion and Q&A session, but maybe just before we start, let me just remind people that you can ask questions in the Q&A chat that's available at the bottom of your Zoom screen. Please, if you'd like to direct your question to a particular person, just identify the person that you'd like to answer your question. If not, we will then just pose the question to the whole panel. I think I would like to kick off some of the discussion. I mean, I think what's interesting about these papers is that you've got that excessive pricing thread that's coming through in all of them. I think even the one that's focusing on competition and public procurement, it has an element of that discussion that really says, and then what happened? Can please, if you're not talking, mute your microphone.
stay. Yeah, Dana, man. Oh no, it's making me pretty funny here.
Sorry, someone in the audience or on the panel has a microphone on. Would you please mute yourself? Thank you. So, but I mean, I do have specific questions that I'd like to ask the panelists, and I have comments that I can share with you, I think, after the session. Starting with the first paper, Dangi, so I mean, I think I raised this initially. Your paper goes through this discussion about, the regulatory framework for public procurement, and a discussion that I wanted to see, but that didn't feature as prominently, was around how such policies or regulatory frameworks can balance multiple objectives. And when it comes to public procurement, what we're looking for, we're looking for a design that not necessarily maximizes, but promotes competition, that also achieves broader policy goals such as Black economic empowerment, but also particularly because at this moment in time, we're thinking about economic recovery, we would want to know that public procurement is also seeking to preserve productive capacity. And if I can just frame that question a little bit more, a lot of research that has been done indicates that public procurement has privileged BEE even at the expense of, of procuring from a non-compliant BEE company that produces locally, that has employment, etc. And then depending on where the BEE entrepreneur who wins that tender sources the goods. So for instance, if those goods are imported, then what you have achieved is a wealth distribution, basically, right? With very limited benefits for the rest of the economy. So then how, in your view, do you think these multiple objectives should be balanced in an appropriate policy for South Africa?
Okay, thank you very much, Pamela. So I'll try and answer your question, although it was multifaceted. So my view is that, in as much as, the regulatory framework provides guidance in terms of how, the procuring institutions can, go about the procurement process, I think there is an element, like you're saying, that, like SMEs, there is, that element to say that they haven't yet benefited from the state contracts. And I think what's interesting, more especially with the draft public procurement bill, is that the state is trying to, introduce the regulator and looking at the, the objectives and the functions of the regulator. It seeks to, sort of like promote, inclusion of SMEs, as well as, but I think what's lacking is the issue around transformation, ensuring that, there's that transformation aspect. There is a need for the regulator to be, empowered. And I think also, in terms of, competition, holistically can play an important role. For example, it can allow for innovation, where, you're not only focusing on your, your typical products, but you can also, you're not focusing on products that are manufactured by, your incumbent firms, but you also allow for SMEs that are innovative, that, manufacture, substitute products to also benefit from the procurement process. And I think the state, given the, the magnitude of public procurement in this country, can use that bargaining power to ensure that even in the contracts that, it awards to, to firms, a certain portion of that has to be, for SMEs, there has to be some SME development in that. So I think in a nutshell, there is those shortcomings in the current regulatory framework, but I think there is some silver lining, more especially looking at the, what the draft public procurement bill seeks to achieve.
Sure. No, I mean, I think this really is a complex balancing act that needs to be played out. But I mean, I think it's really critical that the design of these policies really consider what it is that we are trying to achieve, both from transformation perspective, as well as building the productive capacity of the economy. I mean, there can be no growth if we cannot make things. And I mean, I think you spoke a lot in your presentation around the COVID cases. And now I think this is linking to the presentations by Nonkululeko and Barang, whom I'll bring in. To what extent do you believe that this is opportunism that occurred across the market? I mean, not necessarily in public procurement, but in every kind of, like, even in retail, versus it being a specific procurement issue, also maybe slightly separately from corruption?
Yeah, I think there has been an element of opportunism, because looking at some of the firms that have been investigated by the Commission authorities, you find that before the pandemic, they were not supplying these PPE products. But they sort of, saw this as an advantage that they can take to profiteer from cash-strapped consumers. So I think, even the regulations themselves, they couldn't prevent that abuse from taking place. So I think what we have seen in terms of excessive pricing is also the issue around, being able to exercise your market power and to charge, above what, like the normal cost of production. So in as much as there has been corruption in some of the cases, which is largely facilitated by public officials who also benefit from these contracts. But to a large extent, there has been opportunism in the public procurement process.
Sure, thank you. And then, I mean, this question is to Nonkululeko and Barang, but I'd like Nonkululeko for you to weigh in first. So much of the discussion about the COVID-19 excessive pricing cases have been around dominance. How do you determine dominance? Do you use the traditional tools of first defining your product market and geographic market and then establishing dominance on that basis? Or are you able to use alternative means of establishing dominance? So, I mean, to what extent, I think your presentation started with, there's a strong rationale for why the Commission would deviate from the standard way of doing this. So to what extent do you believe that what the Commission did in the COVID-19 cases is actually applicable to standard excessive pricing cases? But just in terms of the assessment of dominance.
Okay, no, thanks, Pam. I think context really matters. So ordinarily, like you point out, we would look at dominance, we'd need to define the market. But in a situation presented to ourselves, like a COVID-19 case where you had like supply restrictions, restrictions on traveling, excess demand, I think we would need to sort of depart from the standard way that we would assess traditional dominance, because you need to look at the context, you need to look at the market, you need to look at what was happening around that time. So I do think, as you kind of alluded to, that we would have to look at different tools of assessing dominance. And in this case, the debate has been around whether or not we can confer temporary market dominance on firms who would not typically be dominant under traditional excessive pricing or abuse of dominance provisions.
Sure. Barang, I think before you answer, I'd like to add on maybe to that question, as you mentioned the oil case from the 1970s, where temporary dominance was actually used. To what extent have you seen reliance on that particular decisions in the other jurisdictions around the world? Or if you can add an answer to that to you when you give your response.
Thank you. In EU, the reliance on that particular case is rather limited, but we have seen some cases in being decided But the main difference between the EU as a jurisdiction and South Africa and US, in US, you don't really have the dominance requirement. First of all, US does not prohibit excessive pricing on the federal level. It does so on the state level, and mostly through price gouging cases. Through a presidential order, executive order by President Trump, during the COVID-19 crisis, excessive pricing, price gouging was also prohibited on the federal level. So the US authorities, now they base their decisions on that. Still, dominance is not really the same kind of deciding issue. In the South African cases, in the two cases which I have read from the tribunal, the Babelegi and Dischem, it's a bit of diverging approach, I would say, only in those two cases. In the first case, it was common cause between the tribunal and the undertaking that they did not hold more than 5% of the market shares. However, they refer to the South African competition law, saying that dominance is when you can control prices and exclude competitors or behave to an appreciable extent independent from your competitors, which is basically, it is from EU law that we have that formulation. From General Motors and also United Brands, which was rephrased, and also Hoffmann La Roche and so on. So in EU, if you cannot show a dominance, you have an uphill as a competition authority, because the undertaking will have a field day in the appeal courts, saying that you have not even made the prerequisite formal legal test, which means that you have to establish dominance. However, in the case of a pandemic, the general statements by European Competition Network and so on and so forth, but also if you look at the ABG oil case from 1977 or something like that, I think, it says that, well, there can be times where a market share approach is not feasible, but it's very underdeveloped in EU. So I would say that basically you kind of need to establish at least a temporary dominance quantitatively. In this case, in the Dischem case, in the Babelegi case, sorry, it was more a qualitative approach. And there are some exceptions to be taken with that.
I think before maybe I ask any follow-up questions on that, Rahma, do we have any questions in the Q&A chat?
Yes, we do have a few questions coming. The first was about what the view of the panelist, the first panelist, so that was Tankiso, regarding the use of deviations by public entities. And the reason that this was asked was because the deviation process is considered to be vague, and National Treasury makes mention of procurement under emergency situations, but it doesn't just define what an emergency is. So that's the first one. There's just been a new question now, a few more questions now. Should I read all of them?
No, I think perhaps let's get Dangiso to respond to that one, and then we'll take the next one.
Okay.
Oh, actually, sorry, Rahma. Maybe combine that with the last question, which is also about procurement.
Okay, sure. This is for, are you talking about the one from Hari Prasad Govender? So,
no, the one from the anonymous, the one about the Supreme Court appeal.
Yes, there you go, sorry. The Supreme Court of Appeal has just ruled that state-owned companies cannot disqualify prospective contractors who are not majority Black-owned without first considering the price and proposition of the tender. To what extent has South African public policy resulted in high prices, and as far as low prices offered by firms that are not preferred tend to be lower than those of companies that are preferred who happen to source from the non-preferred firms? is it not time to look for real transformation in terms of participation in the economy by focusing on skinning at manufacturing level and ownership?
I mean, thank you, sir. I think those are quite all for you, given that you're the only one that wrote about that. Perhaps your co-authors would like to step in as well. That's fine.
Yes. I think there was one that was made before regarding transversal contracts. I think maybe let me also just respond to that. But I'll also allow my colleagues to add. So in terms of the transversal contracts, there are reasons, for and against transversal contracts, in a sense that, in as much as you'd want to conclude these contracts, for national strategic importance, but you also must be mindful of the competition concerns that can arise from such arrangements. And I think one being, awarding a contract to one market player, can entrench its dominance and also, increase its market share in the relevant market. And I mean, what we're seeing in terms of, the, international experiences, there's been some emphasis on framework agreements, which are more short-term, and they allow, for participation of, multiple players in the contract. Also the rotation of players within that contract. And I think what's critical, this allows for competition, more especially on price, quality, as well as ensuring that, some of the, issues around SME participation and that, there's rotation, is achieved. So I'll hand over to Songezo just to respond to some of the questions that have been asked.
If I may carry on and pick up from the question on transversal contracts. Good afternoon, everybody. Thanks so much, Moderator Mondliwa, for this. Appreciate the opportunity. Transversal contracts, they can go either way, and it really is a question as to which of the policy considerations in that given administration are important. There's absolutely no doubt, as Dangiso has mentioned, that transversal contracts absolutely have an effect of entrenching dominance or monopolizing a particular segment. And there are only ever going to be a few players who could do that. That, of course, at the same time does maintain a sense of efficiencies in relation to the costs of procurement. I mean, procurement as an exercise can be very costly for the government. And that's why here and there, transversal contracts would be important. I'm looking at the Treasury Guide to Transversal Contracts, and it doesn't really tell you much. So there isn't much that one can look at there and get a sense as to whether or not this is desirable, a practice in procurement for the country. And the question really then becomes, what do you make, as Dangiso has referred to, the constitutional promise that embeds within itself transformation and is further extended by how you read the preamble to the Competition Act. It really is about getting more market players involved and transforming the economy. So at least on the thinking and the basis of that, one would imagine that transversal contracts are not in keeping with the kind of transformation that South Africa is looking to. So you might end up probably paying slightly more on a contract by contract basis, but the effect of that is in relation to transforming the market. It is quite important in getting more players involved. Talking about that final comment, the triple PFA, preferential policy, that act, you know what I'm talking about. I just get myself in a knot. It really is a misnomer, and I'm responding specifically to the gentleman or the lady in Anonymous's context. It doesn't matter what you do as a qualifying entity. If you don't come home on price, you're stuffed. You're not going to just get that contract, either on a split of 80-20 or 90-10. So you can get 10 out of 10 for transformation targets or 20 out of 20 for non-price factors. The price factor accounting for at least 80%, at times even 90%, that's exactly how the big guys get those contracts. Ostensibly in the implementation of the triple PFA, price is too. So you've got to look at non-price factors. I'm glad in the context of how this new act, Public Procurement Act, is being drafted now, not in so many words, but I do get the sense that there's some acquiescence to the fact that The PPFA, as per section 217(3) of the Constitution, hasn't yielded the returns it ought to have in 23 years of public procurement, if you trace it back from the 97 Green Paper. And section 26 thereof is instructive in that the minister must prescribe a framework for preferential treatment for categories of preferences and the protection or advancement of persons or categories of persons previously disadvantaged by unfair discrimination in procurement. You would think you wouldn't find that particular section if the PPFA was sufficient an instrument to deliver on that promise. So we can be very sure on the reading just on that section, the PPFA not long from now will be taken care of, and it will be out of the statute books, or certainly not implemented if 26.1 is something to go by. So in sum, we are talking about market players just by using the existing legal framework continuously getting entrenched because there isn't enough emphasis on what would otherwise qualify as set-asides, subcontracting, and the indicators that are important to them. So at times, breaking up a contract, instead of saying 100% to Nonkululeko, who's then going to give us a piece of the pie between Pamela, myself, Tankiso, and whoever else wants to participate, you actually say, Nonkululeko, of this contract, you're only going to bid for 60%. The balance of the 40% will be bid by Tankiso and Pamela and Songezo, who then qualify for these particular indicators that you want, be it women, be it youth, persons with disabilities, as the case may be.
So we are running out of time, so sorry, I'm going to ask you to...
I beg your pardon, I'm sorry.
Sure, thank you. This is the problem when you give lawyers the platform. I think there's one last question that we'd like to take from the chat. Rahma?
Okay, it's a question from James. If we are to develop a competition law that is more responsive to participation and inclusion, as suggested by Judge Davis, then do we not need a broader conception of relational dominance?
Any takers for that particular question? Not. Okay then. Oh, Baran, go ahead.
Generally speaking, I am in favor of a rather consistent and stringent competition law enforcement, also regarding excessive pricing. That puts me a bit in the minority of the field. However, I do not think it to be feasible or reasonable to try to use competition law as a magical wand to solve all evils in the world, because we have other laws to be able to rely on that. I would not use competition law as inclusion, because we have this debate in Europe about the tech giants, right? Google and Facebook. So we have a discussion ongoing that when they become too large, without any abuses, right? Just their sheer size, makes it impossible for other to be included. Okay, then you have a case, but then you can argue it along, economics, say, and use empirical, because facts over theory. So if you use empirical data and you show that, well, you are Google, and when you are threatened by a competitor, you just buy them up, which means that there will never ever be another Google or Facebook or whatever and so on. So in this case, yes, you have an inclusion case, but otherwise I would be rather deferring to other parts of law.
Pamela, your mic.
Thank you. Thank you, Barang, and I'd like to thank all my panelists for an engaging session. I think the session points out exactly the importance of competition authorities as well as regulators, because key issues around, the harms that happen when there's no watchdog, watching how firms interact in practice has really been quite extensive during this pandemic, and including the level of corruption with procurement. Given our country's context, is really very much problematic. But to close off on Barang's point, I do think very much that in the South African context, inclusion has to be a consideration, and this is very much enshrined within the Competition Act itself. So we must be continuously thinking about, how to balance the various perspectives or policy goals that are within the Act. And I think this is really perhaps time for us as the Competition Authority to really start thinking about how do we truly engage with competition as a process rather than an outcome in the way that we carry out our work. Thank you very much to everyone. Have a good afternoon, and thank you, Nandi, for allowing this opportunity.
Thank you, Pamela, and thank you again to everybody for this really high level of participation. And to the panelists, thank you for your contributions. Pamela, as always, you're a pro at generating thoughtful conversation on competition issues. So thank you for lending us your expertise once again. Before I tell you all what's coming up, I should let you know that the presentations you've seen will be available on the Competition Commission's website once the conference is over. I did see a question related to this earlier on in the chat. So you can rest assured these presentations will be on the Competition Commission's website. So now for what's coming up, we're going to go for a break now, just for a short while. Please join us for our first plenary session of the day, and that's going to start at 3:15. You don't want to miss it because we have a keynote address in that session from Andreas Munt, who is probably well known to everybody here. He is the current chairperson of the International Competition Network, the ICN, and he's also the president of the Bundeskartellamt. He'll be followed by a high-level panel to discuss prioritization post the COVID-19 period. And that panel will be moderated by Hardin Rachisusu, who's our Deputy Commissioner. So please join us at 3:15. Thank you, everybody.
Bye, Nandi.
Bye-bye, everybody. Thank you very much for your participation.
Okay.
quarter-past, we're back on the saddle. I beg your pardon for being the bearer of good news. You probably do want to switch your television sets off. Otherwise, we might run the risk of seriously competing with what's happening in the United States. Massive election taking place last day today, November 3, and vote counting starts in earnest tonight and tomorrow. It might be some time yet before we find out whether or not America retains red or the tide turns to blue. That's a story for another day. What is more important now is to find out what is going on in the world of COVID-19 related businesses and the priorities for regulators in all these jurisdictions around the world. Francis in Kenya, Norman, former chairperson of the Competition Tribunal here in South Africa, independent economist, Dr. Thabile Yoka is also on the line. Of course, the moderator being the Deputy Commissioner, Mr. Hadin Rachisusu. Welcome, everybody. Welcome to the final session for the day, 3:15 until 16:30. Make sure to be attentive and ask the questions that really do matter without any fear of reprisal this time around, because you can always hide behind the fact that it was a conference and you were engaging in academic enterprise. Competition policy prioritization and implementation in a post-COVID society. Before the actual moderated session, of course, I do wish to introduce you all to Andreas Mund, who is the president of the Bundeskartellamt, that is the Federal Cartel Office in the Federal Republic of Germany, of course. We know Andreas very well as the chairperson of the ICN, International Competition Network. Let's take then, please, the keynote address now, after which we will engage with Dr. Thando Vilakazi, Dr. Francis Kariuki, Norman Mayo, and Thabile Yoka. Andreas?
Dear Tembin Kosi, dear Mrs. Mansway, ladies and gentlemen, I'm very happy to participate in your virtual conference in South Africa, and I thank you very much for the invitation to take part. As the president of the Bundeskartellamt, and the Bundeskartellamt in general has a long-standing relationship with the South African Competition Commission and the Competition Tribunal. Tembin Kosi Bonakele himself is a member of the steering group of the ICN. He is an ICN vice chair, and both of us have known each other for many, many years. South Africa, by the way, also together with the Competition Tribunal, has always been a very strong player in the ICN from the beginning. It was a founding member back in 2001 in the ICN. David Lewis was also the chair of the steering group of the International Competition Network. South Africa has hosted the annual conference of the ICN. There's a lot of working group leadership in South Africa, and South Africa hosted several ICN workshops. So you can see easily this important role that South Africa has played in the ICN, but not only here, also in other international fora like UNCTAD or the OECD. So this is why I'm all the more happy to contribute today, given this long-standing international relationship between us. We are in the middle of the COVID-19 crisis. South Africa has seen one of the toughest lockdowns in the world, has lost many jobs, although the statistics today look better than in other countries in South Africa. COVID-19 is casting its shadows on everything. It has triggered an economic crisis around the world. It is not just an economic crisis, but it's a crisis for societies that are confronted with distortions they have not seen before in this way. Our experience over here in the Bundeskartellamt is, in these times, nobody calls for more competition. Instead, people call for a strong state. And I agree, in these exceptional times, the state cannot stand at the sidelines. States have to act. And competition agencies have to react as well. They have to act in this changing economic environment. As competition agencies in this crisis and during the crisis, we have tried to take a joint approach in various international organizations, in UNCTAD, in the OECD, and of course in the International Competition Network, the ICN. In the ICN, we have reacted very quickly. We have set up a joint statement by the steering group with considerations that related to competition law enforcement during the crisis. Our message was twofold. The first message was that we were ready to adapt our approach in these unusual circumstances. But the second approach was that we reaffirmed the relevance of competition to economies in crisis, and that we urged the members of the International Competition Network to remain vigilant, to make clear and to send up a strong message that competition is not the problem, but it is part of the solution. So all areas of our work are affected by this COVID-19 crisis, be it antitrust, be it merger control, or abuse of dominance. We should not let the crisis change our priorities. In some areas, we have to take a new approach. In some areas, we even have to sharpen our focus because the crisis accelerates problematic developments that have started already before. So I quickly want to take a short look at the various fields of competition law enforcement during these times. My first look is on the cooperation among companies during the crisis. Over here in the Bundeskartellamt, we have a long tradition of giving advice to companies what is allowed in terms of corporations and what is not allowed. Now, during the crisis, of course, we had to give even more advice, sometimes more intense, sometimes it was a very urgent case, and sometimes it was even complex. But in the beginning, there was lots of cooperation among companies, for example, with regard to logistics. Later on, there were other questions that we had to solve. For example, how to reactivate a value chain after the value chain has broken down completely during that crisis. From a legal point of view, companies had to cooperate much more during that crisis than before. So there was a strong demand to give advice by the Bundeskartellamt. We did not take a lenient approach with regard to corporations, but of course we took into account the specific circumstances during this exceptional urgency. If markets don't work, competition has to be assessed differently. So what was important for us was that the corporations were appropriate and proportionate. It was important that they were non-discriminatory. And of course, it was very important that they were limited in times. So that sent out the strong message: you are allowed to cooperate, but please, no cartel agreements during that crisis. What was difficult, of course, and that remains difficult until today, were dawn rates. What remains difficult is to impose fines because companies claim their inability to pay a fine. We have to cope with this. We have to develop concepts for that. But I think we are on a good way here. Another issue we have to take into account is state aid. We do not have competences in state aid as Bundeskartellamt, but of course, state aid is a competition issue. I agree again that the state cannot stand at the sidelines in these difficult times, but it must also be clear that state intervention, state aid, is always difficult. It's always problematic because it distorts competition per se. That is easy to say. Some receive state aid, some don't. Some benefit from this advantage, some don't. So you have to be careful about that, and you have to give state aid with certain measures or under certain conditions. And I think these are the same that are valid for cooperations among companies. State intervention needs to be fast and focused. It needs to be proportionate. Plus, it needs to be limited in time. And I think if this is obeyed, if this is taken into account, state aid and state intervention is something that might be feasible under these conditions. Another area of our activity is clearly merger control. It is our task to prevent markets from dominance. We had a sharp decline of merger filings at the beginning of the pandemic, 50% alone in May. Now we are back to normal almost. We have seen difficult cases. We have seen merger cases with a high risk of insolvency. We have seen cases where it was difficult to impose or to enforce remedies. So here we had to be flexible. But one thing is also for sure: there cannot be a pandemic bonus in merger control in general, because a crisis is temporary, whereas mergers change the market structure forever, and we can only run behind it afterwards with abuse control. So no crisis bonus in merger control. One focus remains, and this is digital markets. Digital markets are defining the agenda of competition agencies around the world, and even more so during the COVID-19 crisis. Platforms have even further expanded their market power. Amazon has tripled its net income in Q3 of 2020 to 2019. Google had a rise of the net income in Q3 by 59% and Facebook by 29%. We have to act in this respect, but we act in a challenging environment. We see a rapid technological development. The issues are embedded in policy considerations. We see a touch of protectionism around the world. And we always work to a certain extent at the intersection with other areas of law, with consumer protection law and data protection law when it comes to enforcing competition law in digital markets. Fortunately, there has been a huge groundwork by competition agencies around the world, again, embedded in our activities in international organization. And here again, the ICN has introduced this topic at a very early stage. I remember our Sydney annual conference back in 2015, when we have done a special project on online vertical restraints. Afterwards, there was a growing number of projects and sessions at each annual conference in Singapore, Portugal, India, and Colombia, culminating in 2020, where during our first virtual annual conference in the ICN, the digital economy was an overarching topic during the whole conference, with 2,500 participants only on the first day. There have been successful cases around the world. I can here only speak for the Bundeskartellamt. We have seen successful cases against Amazon, against Facebook, against Booking, and I'm very happy to see that the Facebook decision of the Bundeskartellamt has made it into the excellent report of the South African Competition Commission called Competition in the Digital Economy. We have seen cases on price parity clauses vis-à-vis Amazon, vis-à-vis large online hotel booking platforms. And we have learned a lot during that time. We have learned, as competition agencies, how to deal with data-driven market dominance. New cases make the headlines today. So despite all these cases, also the new cases, we also see around the world that competition law might need at least some adjustment. This is why you see lots of legislative initiatives here in Germany, in Europe and in other parts of the world. The digital economy will be an important part of this conference during day 2, and I'm sure that this conference will give valuable input on this topic. To conclude, let me mention one last topic, that is the discussion on sustainability that is gaining speed. It seems that the pandemic has made us more aware of our vulnerability. The sustainable use of resources has become one of the major issues of our time. And competition authorities, of course, come into play when companies need to cooperate or say they need to cooperate in sustainability matters. So that is the huge question also for us as competition agencies, how to take into account sustainability aspects in competition assessment. There's a broad debate on this going on. Here in Germany, we just had a huge conference on that with our academics from German universities. And this will be a special project for the next ICN annual conference in Hungary in October 2021. So finally, to really conclude, I have 3 messages today. First message is that we as enforcers, we need to take into account post-COVID scenarios even in the middle of the crisis when we apply competition law now. Secondly, the crisis affects all areas of our work: antitrust, merger control, and abuse of dominance. But our rules need and allow us to be adapted to a changing environment if necessary. And finally, my third message, we need to be focused and to keep focused. We need to remain vigilant as enforcers, especially in the areas of merger control and in the area of abuse of dominance. The good news in these times is that you can count on the international community. Competition agencies are not doing this alone. We have strong international fora like the ICN, the OECD, and UNCTAD. And I'm pretty sure that if we all try to be together, to get together in overcoming this kind of crisis, not only in the area of competition, in all kinds of areas, we will be much more successful than doing it alone. I thank you very much. I wish you a very fruitful event. I'm absolutely sure you will give valuable input to the international debate on these difficult topics. Again, it's a pity I cannot be with you physically, and I send my best wishes to South Africa. Thank you very much.
Thank you very much, Andreas, for those remarks. We will now move on to our panel discussion, and to start this, I just have some thoughts I wish to share with you to situate the discussion. So in UNCTAD's 2020 Trade and Development Report themed From Global Pandemic to Prosperity for All, Avoiding Another Lost Decade, Secretary General Mukisa Kidui makes this observation. COVID-19 has served as a reminder that we live in a closely interdependent world that brings opportunities but also carries dangers. It has, just as importantly, shed light on a whole series of pre-existing conditions, from heightened inequality to unsustainable debt and rampant environmental destruction. that were left unaddressed after the global financial crisis. The world at the end of 2019 was, in truth, a good deal more fragile than many were willing to acknowledge. As a result, COVID-19 obliges us to think carefully about what makes for healthy and resilient communities at the global level as much as the local level, and take to heart the lessons we have learned in the last decade. And now, equally, competition authorities had to respond to the economic disruption of COVID-19 crisis, with many granting exemptions to firms to ensure coordinated responses, and some taking action against price gouging. Looking ahead to a deep global recession and devastation to sectors such as the airline and tourism industries, there are likely to be challenges around failing firms, industry restructuring, and calls for cooperative arrangements in rebuilding the economy. We have started with quite insightful input from the president of the Bundeskartellamt, Germany, and chair of the International Competition Network, Mr. Andreas Mund. He emphasized the need for competition authorities to stay focused on priorities, but if markets don't work, competition will have to be assessed differently. And noting also that competition regulation may need some adjustment to fully address challenges brought about by the COVID-19 pandemic. This session will therefore focus on where competition authorities should be focused during the post-COVID period and what approaches should they adopt in addressing these challenges. To dissect the challenges presented by the COVID-19 pandemic in the world economic order and competition authorities, especially those in developing economies, we have a distinguished panel of speakers. And given their respective roles in shaping competition regulation, they need no introduction. We have Acting Judge Norman Manoim, who is Acting Judge of the High Court in Gauteng and the former chairperson of the Competition Tribunal for a decade, who is joined by Dr. Thando Vilakazi, an Executive Director of the Center for Competition Regulation and Economic Development, and a part-time member of the Competition Tribunal, and Mr. Wangombe Francis Kariuki, who is Director General of the Competition Authority of Kenya. Our discussion will not only focus on competition regulation, but also broader policy considerations. And to complete the panel, we are pleased to be joined by Dr. Thabi Leoka, who is an independent economist and also serves in the Presidential Economic Advisory Council in the government of South Africa. Time permitting, we shall take a few questions at the end, so please post your questions on the chat. Let me start with Dr. Leoka. We hear a lot of numbers around decreases in GDP with 8% contraction predicted for 2020 and the substantial loss of employment. Given the devastation we are seeing, do you think there will be lasting structural damage to the South African economy, as well as other developing economies, or even the global economy? Is the economic recovery a matter of time, or are there areas that will never recover? Over to you, Dr. Leoka.
Thank you very much for the introduction and also the opportunity to speak to at the Competition Commission conference. Very good questions. The South African economy has been ailing for a very long time. Even before the pandemic, we were actually in a recession. And the numbers that have been punted about in terms of economic growth have ranged from 8% to 10%. I currently forecast economic growth for this year to a contraction of around 9.2%. And I think that the risks are on the upside. So when we look at what is developments that are happening in Europe, we realize that many of our trade partners are, their borders are shutting down, they're going into their second wave of this pandemic, and this will impact on the global supply chain. And this will definitely impact on our sectors such as manufacturing and mining, which together account for over 25% of GDP. So we will struggle to recover. And if we look at what happened in the global recession of 2008, 2009, it took us around 5 years to get back to pre-Great Depression levels. And we then had lost about just over 1 million jobs. And this time round, in the second quarter, Stats SA revealed our unemployment rate, and we now know that 2.2 million South Africans are unemployed. And the numbers don't look good, because if you look at employment, I think around about 39 million South Africans are within the working age population. Out of that, 14 million South Africans are actually in employment, and 18 million South Africans are unemployed and rely on the social grants. So as we recover, we need to correct that, and we need to ensure that our recovery is inclusive. The other thing that has changed, unlike the Great Recession, is that we have changed. The world has changed so quickly in the past 6-7 months versus the past 3 years. The previous speaker talked about companies such as the fintech companies doing exceptionally well during this period. And unfortunately, what that has done is that we're seeing what is now called the K-shaped recovery. So we will see huge unemployment and inequality, not just in South Africa, but globally. And so the arm of the K is those who have invested in the stock market, those very wealthy people whose wealth has quadrupled during the pandemic. And the leg of the K are those people who have found themselves vulnerable, unemployed, and unfortunately, they are the bulk of the population, even globally. So as a community, a global community, this is what we need to look at. How do we emerge out of this pandemic as equals? How do we ensure that the inequality gap is closed? How do we ensure that there's equity even in those companies that have done very well? We need to close the inequality gap, and they need to play a significant role in closing this gap, because to be honest, they have created this widening gap and this K-shaped recovery that we're starting to see. Where does the future lie? I think that unfortunately, there are companies that are not going to fare well. Those companies are those companies that are not able to get funding, companies that are not agile, companies that haven't been able to pivot. And we've been talking about these words throughout the pandemic, and as if everyone can pivot and everyone is agile. And unfortunately, that's not the case. The other thing is that we need a different skill set. I think that for the past, almost a decade, we've been talking about AI and fintech and digitalization, but we haven't really adopted it as much as we should have. And now I think that we're seeing companies that are adopting this faring better. And in terms of even being protectionist, and we're seeing that globally as well. And when companies start replacing human labor for machines, that also has negative consequences for the unemployment rate. So I think as a country, we need to be aware of it. We can't be laggards, because this is a global phenomenon, and this is a new paradigm. But then we need to ensure that as we move forward, it is inclusive and everyone has room to play within this new paradigm. The other thing that concerns me in terms of how we're going to develop is the lack of finances that we have as a country. About last week, we had the medium-term budget policy statement. And again, we had very negative numbers in terms of our fiscus. We have increasing deficit and also debt to GDP numbers. The gap between the revenue and expenditure is widening. And we need to shrink this deficit. And I don't think that's one of the biggest challenges, because we're relying on wages and the wage bill to shrink without having agreed with labor on how we're going to do this. So I think that is one of the biggest risks, because I don't see us shrinking this deficit. And what that does is that currently the composition of our expenditure means that it's crowding out investments and then crowding out social investment. So as we are emerging, as we emerge out of this pandemic, it's going to be very difficult for us to do so without the financing to do so, and especially the social financing that typically funds education, social development, infrastructure development. And so this is, again, where the private sector needs to step in and ensure that there's this partnership between the private and public sector to invest in South Africa and invest in social infrastructure and also bulk infrastructure. So very, and there are lots of uncertainties. There are a few opportunities. We have to think outside the box, but we need to ensure that as we develop equitably as a country, but also as the global community.
Thank you, Dr. Leoka, for the opening comments on the state of our economies. Now, let me turn to Dr. Lakas. Policy coordination will be critical for economies to achieve economic recovery. How can competition, industrial and trade policies be used together to drive economic recovery?
Thank you, Deputy Commissioner, for this opportunity, and to the Commission for a great program thus far. I think that it's a very tricky place that we're all in. I think Dr. Leoka describes very well the kind of quagmire that we're in, right? Amongst other challenges, there's this kind of pressing imperative to have or to protect jobs, to protect kind of what productive capabilities do exist in the economy. And my worry with all of that, before I get into my kind of specific remarks, is that that implies a tendency to focus on the short term. Of course, it implies a tendency to lean towards protection of current jobs, incumbent operators, and the kind of current structures of our markets that have in fact got us to this place in the current crisis where there is no dynamism and there wasn't resilience because too much of our economic activity was concentrated arguably in the wrong places. Frederick Jenny makes this point in his recent article as well, is like the fact that we've allowed the markets as they have to allocate resources as they wish has meant that many economies didn't have the scope to maneuver to actually respond in terms of being able to produce goods that were required in this crisis, right? And so in many ways, it's kind of highlighting that markets work, but they actually need to work, as the Judge President was saying earlier, for more of the population. And they need to drive towards different objectives. I think there's a tendency to focus on stability in the current environment, but I think there's a few other things that I would suggest are also very important. In this, I would include a few different things. I think that if we're to build a resilient and dynamic economy over time, and this cuts across policy areas, then I think you have to focus on aspects such as diversification. You have to focus on how do you create channels for new ideas, new skills, and new business models to emerge, right? And that means taking risks and making certain short-term sacrifices, which fortunately I don't have to make as I'm not in the policy position. But speaking of who is in the policy position, I think it's a significant moment in the kind of South African context, at least, that just recently the ministry of that the competition authorities fall under has been redefined as the Department of Trade, Industry and Competition. Now, this is may well be quite symbolic, but I also think it sends a very important message about the fact that competition law specifically is going to play should play a very important role more broadly in cutting across policy areas as well. The window is there, and I think there needs to be focused more, at least, on developing a more broader national priority, and I would suggest even a policy framework about how are we actually going to achieve inclusion. I think it's been left to anyone's guess in terms of how we're actually going to do it, and unfortunately it means that often the Competition Commission has had to bear the burden of achieving this thing. More broadly on policy coordination that's required, maybe just to make some other remarks, I think that one of the challenges in South Africa, and we've seen this also in other countries in the region that we do research on as the center, is that regulatory toolkits often don't pull in the same direction. So you might have the competition authority with a particular focus on public interest and small enterprises and inclusion, etc. But if you look at your rules of the game in energy policy or in telecoms policy, etc., they do not prioritize the same objectives. And I think this is a fundamental flaw in the coordination between our various policy areas, right? Because it means that you have these kind of policy directions that are different in different areas, which is a significant waste of time and resources. And I think it's part of explaining why we are in the kind of troublesome situation that we're in currently. I'll make maybe just two more points, Chair, if that's okay. I think that there's a very interesting and important role, centralized role that the competition authorities can also play in terms of policy design. And this is not an area where we kind of traditionally associate competition authorities. But if we think back to the fact that, for instance, there was a time, and I forget the year of these cases, where there was a huge problem with tender rigging, bid rigging in government contracts. And the competition played an important role along with the National Treasury in shaping how you could make the rules for tenders less likely to be subject to tender rigging. Now that for me is policy making. And I think the authorities broadly, especially in the current paradigm, can play a far more dynamic and active role in advocating in various different ways for measures and policy directions that open up the economy and allow for a bit more dynamism and rivalry. And then I think lastly, just to say about coordination, as much as we this environment forces us to think big about a lot of interesting concepts, I think it's also very important to get the basics right. When we speak to a lot of companies in the economy for different research projects, the same issues keep coming out. We cannot get funding fast enough. The form of funding is not appropriate. Policies are not in our favor. Regulatory processes are not quick enough. Departments of government are not talking to each other, etc. Now, we don't need COVID to tell us this is the problem, but I can tell you now that if we don't solve some of those problems, we're not going to solve some of the challenges, especially for smaller firms, that COVID brings to us. And I think it's probably a good time to even draw lessons from the very well-coordinated policy response that we've seen on COVID to a wider, and broaden that to a wider kind of economic policy approach. I'll stop there. Thank you, Chair.
Thank you, Dr. Vilakazi. I think that was quite hard-hitting, if I may say, because it seems to me we know the challenges, and Dr. Leoka, emphasized on this K-shaped recovery that is just not sustainable. So I think a lot of food for thought there. I will now turn to competition regulation. And I shall now bring in Acting Justice Manoy on the question of the form of major regulation in a crisis we face today. Should measures be considered any differently in the context of the economic crisis? Do we put more weight on public interest considerations such as employment, or do we apply the substantial lessening of competition test more strictly in order to avoid any lasting anti-competitive consequences? Justice Manoy.
Thanks. My apologies for not having my video. There is some technical problem that is beyond my talents to actually solve. So if you don't mind seeing a dark screen, I will try and answer the question. Look, I think as far as the legal test is concerned, unless the legislation changes, your legal test remains the same. So what changes under COVID is how you examine the facts and how you give weight to different facts that have got. So the big problem that you're faced with is what's temporary and what is less temporary, for want of a better expression. In other words, how much of your typical merger is going to be a situation where emerging parties come to you and they say, please let our merger through, even though you may be concerned about increasing concentration and lack of competition. We are saving jobs. And so you've got to actually work out how to evaluate that particular situation. In other words, what you're being asked to do is to trade off an increase in market power with a decrease, with a public interest, a positive public interest. Now, that's a question of how you evaluate the facts. So what you want to really do is saying, well, the firm is allegedly failing, the target firm, let's say. Is it failing on a temporary basis, or is this a more permanent structural feature? That's going to be very, very difficult to evaluate, because a lot of the situation, as it were, the macroeconomic background to you is in the government's hands or is in the disease's hands. It's not up to the Competition Commission to make that evaluation. But there are certain small things that one could look at. For instance, is there a difference between a target firm that sells coffees and a firm that sells cars? It may well be that during the closure period, both these firms had to close for a certain period of time. But it's fairly likely that the firm that sold coffees is never going to regain those sales and may genuinely be failing. But the firm that sells cars may be having an opportunity once it's reopened to sell those cars that weren't sold during the time. In other words, its claims to be a failing firm may be less compelling than the guy who sells cappuccinos. And that's the kind of analysis one needs to take in that situation. Then we look at the claims made on the public interest side. It may well be that people will say, we're going to save this firm, we're going to save some jobs, but don't make us save all the jobs, because there'll be no point in actually saving that firm. That equation is going to be very, very difficult to actually decide in how you do that. But I would fall on the side saying, if you're going to if there's a danger that there is a market power employment trade-off, and if a firm is likely to acquire market power, at least temporarily, then it must pay the price in actually a stronger public interest, in this case, an employment condition being imposed upon them for a period that is least likely to occupy what is the balance of the likely COVID period. Then the question is whether you, in a sense, you've got to let the merger through. It is going to be a lessening in competition. They are willing to give employment undertakings, but should you still under those situations trade off the competition problem? After all, you're a competition regulator if you're the commission or the tribunal. I would say in those situations, it's very, very difficult indeed. But it may well be that one wants to introduce structural separation for a time being. In other words, say to the firms, look, you can go ahead with the merger, but the target firms, either its brands or it's certain of its branches, must be held separate within the merged firm for a certain period, in which you assess after that period, you require them to, as it were, re-notify and advise as to whether there's been new entry into the market. If there has been, that's fine. If there hasn't been, you might want to consider whether prices have gone up during that period, and there's justification in telling them to either sell off the brands or the held-offs or the other branches that have been held off until that period. What it does raise, of course, is the fact that you've got to have two inquiries, which make it more burdensome. But it may be in situations where the market power problem is particularly compelling, but there's also a very compelling case for saving jobs, that you use the whole separate thing as a temporary remedy and look at it again once, as it were, the COVID crisis has gone. Thank you.
Thank you, Acting Justice Manoy. It's quite clear you are calling for creative regulation, some form of creativity in navigating our way out of this crisis. Let me rope, on that note, rope in a Director General Kariuki. An important area of debate is whether competition authorities should prioritize certain types of enforcement, such as measures, given the likely greater prevalence of rescue measures, or even enforce with more or less vigor, depending on who you speak to. What has been the approach of the Competition Authority of Kenya?
Thank you, Hardin, and I wish to thank the Competition Commission of South Africa for our continued cooperation in these discussions, especially during this COVID-19, and looking forward to continue with the post-COVID-19 discussions. Hardin, I would like to share with the audience that Kenya's merger regime is suspensory in nature, that parties which meet the thresholds, they have to notify and they have to undergo the due process before they consummate the merger, even during this time of COVID-19. So I would like to say that it's not a merger, it's not a matter of prioritizing, it's a matter of whether we should fast track those mergers, those sectors which have been affected by COVID-19. The other issue is that I would like to indicate is that merger or structural approach to competition maintenance in the market has not been very eminent, because you realize that most of the mergers are approved. Over 90% of the mergers which come to the authority are approved. So from where I stand, I know it's a bit provocative that mergers structural approach to ensuring that markets remain competitive has not been very eminent. So that is what I would like to say. However, having said that, is that as I've indicated, yes, we are fast-tracking mergers in certain sectors which have been affected by COVID-19, and they have also to undergo the due criteria, that is substantial lessening of competition, and also the public interest criteria. But if you can recall, what I've said is that the structural approach has not been very eminent. It means that during this COVID-19 is that we are more interested with public interest criteria in ensuring that we are maintaining the competitive markets and also maintaining the workings of the markets. You have asked me the issue in regard to rescue mergers, that is the failing firms. And I've indicated that they have to undergo the substantial lessening and also the public interest. For example, the authority has to seek evidence that the firm is going under, that the firm is under distress. And then after seeking that evidence and it's presented, then we have to check whether the acquirer is dominant. And if at all it's dominant, it does not stop there. We have to ask ourselves, is that was he the only person to acquire the failing firm? And if at all he was the only person to acquire the failing firm, is that we can go ahead, and we have gone ahead and approved, however, with conditions that, for example, you have to continue supplying the goods or the services, the failing farm was supplying. Number two is that you have to maintain the suppliers who are supplying to the failing farms. And then when also we come to employment, is that you have to continue employing, but obviously is that we have to bear in mind that there is duplication of positions, and therefore we cannot force them to employ all the parties. But also employment goes beyond human capital to the assets which were under the farm which is failing. In terms of the sectors which we are realizing that we have to consider this, it's the hospitality, the hotel industries. Some of the hotels are failing. The supply chain is collapsing. And also in terms of the schools, the private schools, Kenya has been on lockdown. The schools have been closed since March this year. That is about 10 months. And therefore, private schools, we are going to see a collapse of private schools. And if at all there is a now private school which can take over the other private schools, we have to look at each and every case to ensure that the distance which children travel is still maintained or minimized. But having said that, is that we have to be very aware also that the existence and the opportunities for killer mergers is with us, especially in the digital economy, where we have seen that the digital economy is expanding and there are opportunities. And we have to realize that some of the incumbents, especially in Kenya, you know who are the incumbents, they have to be focusing on these upcoming farms so that they can still continue maintaining their market power. So that is the balance we have to undertake. And what my parting shot is that the market structure approach has never been very eminent, and it has been eroded further with COVID-19, but the process and the procedures still maintain, and it will be on case-by-case basis. Thank you.
Thank you very much, Director General Kariuki. Indeed, I think it's quite evident that the public interest clauses and provisions that we have adopted in our laws and principally on the continent go a long way in allowing us to respond to this crisis. Dr. Leoka, you have heard of approaches to competition regulation in major regulation by forces, but now SMMEs are commonly seen as one of the biggest casualties of the economic crisis we are facing. In the competition space, we see SMMEs as key to entry and growth, and ultimately healthy competition in markets. What has government done to support SMMEs, and what could it have done better? Over to you, Dr. Leoka. Yes.
So I think even before the pandemic, not enough was done to support small and medium-sized entities. There was always an issue of how do they access markets and also access funding. And so when the pandemic struck us, it was very clear that these very vulnerable entities are going to be the first to be impacted. And indeed, within a month or so, many of our small and medium-sized entities closed shops. And this is unfortunate because they do also employ, and they should actually really be the backbone of the economy, but because of the structure of our economy that is heavily weighted towards, the oligopolies, these entities have always had to struggle, and they've done so even before, before the pandemic. What the government has done to try and help these small and medium-sized entities is, I think the first one is to to allocate about 200 billion rands towards the loan guarantee scheme. And to be honest, I was never a supporter of the loan guarantee scheme. We've had this before in South Africa, and the uptake has been very low. And the uptake, again, is very low. Just to give you a number, out of the 200 billion, only 100 billion was guaranteed by National Treasury for the SARB to be the undertaker of it. And only about, I think, 16 billion has been extended to small and medium-sized entities. So out of the 200 that's been announced, only 16 billion has been, injected into the economy, and that is insufficient. The other funding that we had was that small and medium-sized entities could access funding from small business department and also from the IDC. But again, they had very strict rules. The informal sector couldn't tap into this market. Many of your small entities could not tap into this market because they're typically very informal. They don't have the requisite tax numbers. And many of their applications, or all the applications, actually had to be done online. So again, discriminating against many of our small and medium-sized entities. The other one that we had was the UIF surplus fund that was also put aside. And we know what happened at the UIF. There has been also corruption there, and the process hasn't been very smooth. And we also had a temporary tax relief, and that has also helped some companies. I think, we could have done better, and hopefully this pandemic has revealed certain fault lines, and definitely the support of small and medium-sized entities needs to be taken seriously for this economy to recover.
Thank you. So in short, really not enough, but I suppose government can do better. And now turning to Dr. Vilakazi, what role should competition law and enforcement agencies play in driving economic recovery?
Right. Thanks, Chair. I'm really excited that at a competition law conference, we're not just kind of talking about the things we usually talk about at competition law conferences, but we're actually expanding the frame of reference and the issues we're considering to a much broader set of issues. And I think this is precisely the point. This is where we should have been probably 20 years ago, right? And this is because we need to kind of be reminded as well why these pieces of legislation exist, and they don't exist for their own sake or to keep a few of us busy in this kind of competition community. We are interested in the outcomes that the competitive process can bring throughout the economy, right? We're not interested in merger regulation for its own sake. We're interested in it because it's part and shapes the trajectory of economic development in a sector, in an industry, or whatever it might be. And it's important to remember that. Maybe to borrow the words of the Springbok coach, which now I'm going to refer to as an economist, Rassie Erasmus, in the recent documentary, Chasing the Sun. He says, we've got to remember to keep the main thing the main thing. And I think it's important, and these discussions force us to remember why competition laws exist and why we have to have these discussions. It's not just about whether or the kind of more technical debates around our comparative jurisdiction in terms of outcomes compared to other countries or Europe or whatever it might be, which are all important debates, but because there's a wider objective that the Act seeks to achieve. And I went back and looked at this again. It reminds us in that it's not just efficiency. Efficiency is one of other goals, including increasing capability in the economy, building capabilities, fair participation, consumer benefit, etc., redress, right? And so we shouldn't be uncomfortable when we force the competition policy and law to have to consider these other issues. And so I think it's really important that we're having these discussions. So that's maybe the first point to make, is that that there's a broader role for competition agencies to play, full stop, right? I think that in many ways, though, upon reflection, I think authorities, and this applies across the region, not just in South Africa, should continue to do precisely what they have been doing as well. Right? So it sounds like a bit of a contradiction, but I think there's some elements of the way, for instance, the Kenyan authority, but also the South African authority, and a few others as well, have actually implemented their mandates. The focus, for instance, on increasingly in the South African area on participation, barriers to entry issues, right, is especially important. The advocacy, not only within competition space, but also to advocate for competition principles and inclusion principles in other policy areas is especially important, right? Especially because, at least in the South African case, and I think this is true in Kenya as well, the authorities hold a unique position in that they've demonstrated strong technical capabilities, independence, reliability, and extreme ability to deliver in economies where many government departments are failing or struggling, right? And so that's lent us, if you want to talk about the broader competition community, the ability to then shape debates in other areas. So we've built the credibility to start to contribute in other policy areas. And I think driving an agenda of inclusion for competition authorities is especially important. I don't think we can afford to keep quiet about some of these issues, right? If we think about the fact that it's taken us so long to arrive at the exclusive lease settlements that have come out of the grocery retail market inquiry, even some of the issues, even some of the findings around the data costs inquiry, etc., right? If there was coordination, if there was understanding of the principles of inclusion and participation in other policy areas, maybe a simple policy decision in each of these areas, maybe by the telecoms regulator, would have resolved the data costs issue 10 years ago, right? But no, we waited for a competition process. We waited for this process. And I think it's because there isn't a wider conception and understanding of how important these issues are for longer term dynamism. And it's not a thing that we prioritize in our research just because it feels nice to have an inclusive economy and include SMMEs, etc. It's not a feel good thing. Dynamism comes from participation and rivalry. Dynamism does not come from a highly concentrated economy focused only on mining and the same lead firms as it has been over the last 25 years. That's not how you're going to build economic resilience. Chair, I want to make one more point in two parts. I think there's a very important role for market inquiries in terms of what authorities have already been doing, because they seem to be able to unlock areas that other policy areas are probably struggling to do with the superior technical ability of the competition authorities. So I think that's very important. And lastly, basics. Research and knowledge dissemination plays an incredible role, perhaps understated, I think, in our jurisdictions in the region. I think Kenya and South Africa are commendable, amongst a few others, for actually publishing information about cases and informing society about impact, demonstrating impact of interventions is especially important. It's the last thing you want to do when you finish the case, to go back and study it again. But it's probably one of the most important things that competition agencies should be doing, because other policy areas then leverage that knowledge base to have far more impactful interventions. And we've seen this. Case studies are there and also available in our book as well with Simon Roberts and Sumaya Goga, which speaks about precisely these issues. Thanks.
No, thank you, Dr. Blakas. Clearly, you say we should keep the main thing, at the forefront. And it's good that Rassi Erasmus won us the World Cup. So maybe this is a positive sign that if we follow his philosophy, we could go further. But also, there is really a lot for competition authorities to think about. Coordination, amongst different regulators, and staying focused. And I think your inputs are quite pointed, towards that direction. But now let me go back to Director General Kariuki, because you are essentially provoking authorities to think outside of the box. A key consideration is what the trade-off is between the short term and long term. Some of the policies and actions, such as exemptions for coordinated behavior and trade protectionism, are usually seen as negative and undesirable policies, but necessary in the short term, given the economic context. how can governments weigh this up, and of course, by extension, competition authorities?
Thank you, Hardin, and it's quite a difficult question, especially this time of the situation we are facing now in the markets. But I have to say this. Exemptions during a crisis are a positive irritant, which we have to live with them, but for some time. Just like the way we spray insecticides in our homes, we live with them for some few minutes and they help us achieve what we want to achieve. Based on that reality is that I have to say, as competition authorities, when we are according parties the exemptions, we should have a baseline, the status of the market at that time, the relevant market. What am I saying is that we should know what are the prevailing prices at that time. What are the prevailing outlets at that time? The essence of this is that with exemptions, if at all we grant them, that the markets do not go below the prevailing or the status of the markets by the time you grant those exemptions. Those are what I would call irreducible minimums. And what Tando said is that market inquiries are very key at the moment, is that we have to approach and understand the status, the state of play in those markets before we grant the exemptions. For example, in the airlines, I know we are going to face a lot of requests for grant of exemptions in the airlines. For example, in the evacuation of cargo for our agriculture produce, the number of flights may decrease after the exemptions we grant. But we have to have also that we have to create minimum warranties the parties have to meet, that you have to meet this number of evacuation, the tonnage, you have to have this number of flights, and also the pricing should not go below or go above when you are coming to us to seek for exemptions. The other issue is that the exemptions should have very strict sunset clauses, that they don't go beyond a number of years. Dr. Tabi indicated that the economic crisis may take about 5 years. And I would suggest that if at all we are granting the exemptions, that they are based on those 5 years. And after the 5 years, we revisit. And also in terms of when we are granting the exemptions, there has to be increased participatory, so that at least you can approach the whole issue from an informed position and what is happening, as we always call it, on the ground. The other issue is that I always advocate for is that we have a clear criteria. So that is non-discriminatory approvals of exemptions, that you have or distribution of goods or the provision of services. This is what COVID-19 was doing. So if at all the exemption is supposed to help that situation that we don't have the decline, then I'll be inclined to give the exemption. Then the other criteria is promoting technical or economic progress or stability in any industry. Industries are facing challenges. Is the exemption going to facilitate the technical progress within this industry? And then the last one is the benefit of competition. That is the other criteria we have to look at in terms of whether it's outweighing. And when we have three criteria met and you tick, I'll be comfortable to give the exemption, and especially in the area where we are supporting the vulnerable members of our society, especially the poor. Thank you.
Thank you very much, Director General Kariuki. Clearly, you're right, and competition authorities have to know the baseline. And this is your message, and it's a very, very important message. Acting Justice Manoim, you have served for 2 decades at the Competition Tribunal, and at the height of the 2007-8 financial crisis, from which some economies are yet to recover. What initiatives must the Competition Commission, as well as other competition authorities, prioritize to promote economic recovery and the building of the economy?
Well, I think when everyone talks about prioritize, it means that you've actually got to make a choice between what you should do and what you should not do. So even though your statute says you should be looking at something or other, you may have to make a prosecutorial decision not to do that particular thing. So let me start off on the negative and saying what you shouldn't be doing. In the first place, and I know it's not the Commission's choice, this is the choice of government, is that what you should not be doing is having to police exemptions. I think now that we're on level 1 of the disaster management regulations and the economy has largely opened, there is no cause for a special exemption based on COVID. So that should go, because otherwise you're just creating a fruitful area for, as it were, meeting place between competitors, and the conversation can veer off from the good public interest that it started off with to something that they shouldn't be doing. Second, and this is going to be more controversial, is the issue of excessive pricing. Yes, there has been excessive price gouging, I would concede, during this period, but the resources put into those cases is disproportionate to its effect on the economy. I mean, I've just looked at some of the cases that you've got, which are, at the end of the day, revolve around what is a very small area of commerce. And so the resources that you've put into that are being diverted from something else for something that is not, in a sense, a durable competition problem of long-standing duration, and doesn't affect a large line of commerce, but yet it's diverted your resources. So those would be 2 areas that I would, as it were, not focus on. Third thing is, I think that the time has come to end the competition-related regulations for COVID. We get back to business as normal. Because as long as those regulations hang around, people are going to come to you with mergers and saying, yes, you recognize through state policy that there's this particular situation. Take that away and you say, well, the economy's opened up, we can go back to more normal analysis. So what then do I think that you should be doing? Well, I think, and James Hodge, I think, has sent a little question around that, is your focus should be on is on trying to get competition that has been eliminated during this period for whatever reason back into the marketplace. And then that I think is a focus on small businesses. So what I think the Commission should be doing is identifying which sectors have become more concentrated since in the COVID period. What are those sectors? Which sectors are strategic to the economy? Are small businesses operating in there? And what is keeping them out from a competition point of view? And to look at both exclusion, in other words, exclusionary acts of dominance by the dominant firms, but also to be looked, and this is the point that James is making in his question, to look at inclusion. So you've got the new buyer power regulations. Now, the buyer power of retail firms has probably increased dramatically since the lockdown has started, because many of their competition has been knocked out of the marketplace, so their power over suppliers has increased. I think that is becoming a priority area for you to have to look at in terms of inclusion or getting those small businesses back into the market. So from the point of view of looking at dominance, exclusion, and inclusion, Those would be very important things. The other thing, and I think there's a point made by Tondo, is that the cases take far too long. What I liked about the Babaleki situation is the fact that you got quite a complex case resolved in quite a quick period of time. And there's no reason why we can't apply that to other cases. In other words, it's very, very important in dealing with dominance that we get a resolution quite quickly. And I think what the Babaleki case has taught is that it's actually possible to get a complicated case resolved fairly quickly, lawyers' games notwithstanding. And you can, without doing an injustice to either side, get that happening quite quickly. So those would be my suggestions.
No, thank you, Justice Manuel. These are very pointed suggestions. I think it's important that, you know, as you highlight inclusion, prioritization of impact, and ensuring an efficient review of matters. I will, at this moment, take 4 questions, one for each speaker, and I'll give my speakers in 1 minute each to address those questions. Kawe, do we have any questions that you want to present to each speaker? One per speaker, please.
Okay, thanks, Chair. Yes, we do have a few questions. And the first one maybe is more directed to the acting justice. But I think also DG Kariuki can also chip in on this one, which says, can merging parties really commit to no major specific job losses in a deep recession, or at least not pull out on a commitment later? So how credible are public interest commitments which are accepted to save an anti-competitive measure?
Is that all? I want to take them all at once.
Take them all. Okay, so
yes,
this one from Shaista is directed to Dr. Lyoka. I think also Dr. Vilagazi can chip in. So the question says, Andreas mentioned state aid and the temptation for government to have a stronger role in providing assistance despite distortions created. In South Africa at the moment, state aid to SOEs is in several sectors with commercial competitors is a reality. How should the competitive distortions created by this in those industries be approached in the context of a difficult economic environment? The last one, I think the acting justice has already touched on it. From James, which says, we saw during COVID that some firms used their market power to shift their burdens onto suppliers or customers. Should we not prioritize policing unfair trading practices, especially against SMEs? I don't know if he wants to add more, or others can also respond to that.
No, thank you very much, Tawe. I will give the floor back to the panelists. I'll start with Dr. Vilakazi, then Director General Kariuki, Justice Manoi, and Dr. Lyoka. And as you respond to the questions, do also give us your final thoughts on what next for combating authorities, especially those in developing economies and Africa in particular.
Thanks, Chair. So I think the state aid or state, state support for firms issues are always sensitive and difficult ones. I mean, Padilla and Petit were saying the problem with state aid for failing firms is that it potentially prevents the kind of natural exit, the cleansing effect of otherwise inefficient firms from the economy, right? And this is coming from that place where there should be free entry and exit and the kind of traditional models of understanding how markets work. I don't want to say anything more on that, except that it's a difficult perspective to deal with in and of itself because of the economies that we operate in as well, where entry and exit doesn't work as you would expect in the traditional market models, where capital is not mobile, where the market doesn't function like we were taught in Economics 101, right? And so often some of these references are back to those principles, but I don't know if those principles apply in some of our economies. Of course they do, but there are nuances, and the nuanced view is required, as Frederick Jenny suggests on these issues. What I will say is that, and we've written quite a bit on this, I think that there is a concern that where there is going to be state aid, certainly in the South African context, I don't know if we've been cautious in terms of the types of conditionalities and outcomes that we expect to see from that aid. And I think we've written one of the chapters in the book I was referring to earlier, the Opening the Economy book, which I think is out now, speaks to the fact that, for instance, on our national airline, if you read the mandate of that organization, it has nothing to do with consumer-facing objectives or promoting more localized travel so that local economies in rural areas can start to grow and leverage tourism, etc. It has none of that. It's strategic goals that have nothing to do with your citizenry. And I think this is a problem, right? Because it means you have not put conditionalities on all that money that you put in. Now, SAA is an unfair example because they've been through a lot, but I think it tells us about how you might want to start thinking about state aid in our context, or state support, and what we require of it in return, right? And I'll make one more point on this, which is that I think there's a very good literature, at least in the competition economics space, on competitive neutrality frameworks, which set the boundaries, and I think Andreas Lund was hinting at this, which set the boundaries or provide some criteria against which you can evaluate state aid interventions. So the proportionality issues, what kind of impact do they have on competition or rivals, importantly as well. These are important frameworks that provide some guidance on these issues. More broadly, I think lastly, I think that competition agencies are in a very exciting moment. I think that there's a good chance that your African authorities are actually going to come up with very interesting and innovative ways of dealing with some of the broader challenges that our societies face. And this is the message that Prof. Fox and others have been arguing for years. And so we look forward to see what happens next, really. And the pressure, I guess, is on the authorities now. Thank you for the opportunity.
Thank you, Adine. And what I've seen is that I'm being crucified for a statement I made in June 2020, which I thought people had forgotten in regard to competition agencies lowering their guns in terms of the industrial policy. But for sure, I still stand with that school of thought that it is important for each and every economy to have an industrial base, however small. And this school of thought, my school of thought, has been amplified by the ramifications of the COVID-19, when we had disruptions in terms of supply chain, that some of the countries which were importing even toilet papers from China, people had to procure toilet papers and fill their bedrooms. I don't know where they were living. So obviously is that I still stand with those. However, is that I'm not an advocate of total protectionism. And I wouldn't say that we ban imports, but in Kenya, we have a situation where government departments are supposed to procure local content, 40%, and then the other 60% can be imported outside the country. And this issue, especially in terms of essential commodities, obviously the current situation in regard to COVID-19 vindicated my position, which I indicated in June 2020, and I still stand for it. So whatever I'm talking about, it's not about protectionism, but ring fencing a certain type of percentage of especially the essential facilities for people, especially whoever I'm calling vulnerable groups, the poor and also the sick, to be able to access these products. Also, what I would advise the government, total protectionism never works. I think the government should focus more on ensuring that the cost of the drivers of industrial policy is lowered in terms of the accessibility to the capital. Number two, the cost of electricity. Number three, the transport charges and also the telecommunications is lowered. Because if at all we protect our industries, or even if we ring-fence them, and these costs are still high, this one, it's going to be transferred to the consumer, and they will not be able to reap the benefits what the government may be intending to reap. To conclude, is that I would like to say, like for example, now in the Kenyan economy, the schools are demanding a lot of sitting desks because children have to sit far. Should we import this from IKEA? I think there's a situation where the local manufacturers can supply this to the schools. Number two, it's also in terms of the masks, the PPEs. The demand across the whole world is very high, and the prices are going up. Why can't we have an industrial policy which is somehow supporting the local production of these, including the foodstuffs for our citizenry? Let me conclude there.
Thank you, and Acting Justice Manuel, and then Dr. Leoka. Then we'll wrap up.
Perhaps let me just repeat the question to me was, can merging parties really commit to merger-specific loss of jobs in a deep recession, or at least not renege on the commitment later? How credible are public interest commitments which are accepted to save an anti-competitive merger? Look, I think that's a very good question. I think the first point is to say just because parties give an undertaking doesn't mean that the commission or the tribunal are obliged to assume that the undertakings will be met. So if the parties are coming along and saying, I want to trade off my market power against X number of jobs, you are perfectly entitled to inquire whether this is a credible trade-off or not. And that can be done by looking at, well, where's the demand coming from that's going to support these number of jobs? If you're saying that the failing firm is going out, why are you going to get back this demand that would save those jobs? Are there redundancies? Are there internal documents of either the acquiring firm or the target firm that talked about jobs and job losses? And if you find that the undertakings are not credible, then you could say, well, we don't accept that you're actually going to be able to live up to your expectations and not come back to us in 18 months and tell us, sorry, we couldn't keep to them. Please let us off the hook. You're perfectly entitled to do that, interrogate that. And if that is the only thing that can save an otherwise anti-competitive merger, if they are not on the face of it credible and the merging parties have the onus to satisfy you that they are credible, then you must not accept them and judge the merger as one on which there is no redeeming public interest, and therefore it must be treated consequentially in that way. So that's what I would say about that. Then there was just one brief question to me about whether I agreed with the tribunal's analysis on the excessive pricing. I don't have a problem with the way the legal analysis was made and the approach that was taken in that case. It's simply, to me, really a question of the prosecutorial resources. And the point that I made earlier is, do we divert prosecutorial resources and the tribunal's resources, which were obviously considerable to consider this case, with so many other things around at the moment? And I think this falls more into the consumer protection type of case, with these temporary price gouging monopolies than they do in competition cases, which should be talking about more durable market power, not temporary market power. That's my own personal feeling. Thanks, Claudia.
Thank you, Justice Manuel. Dr. Leoka.
Thanks, Adi. So part of my question was answered very well by Dr. Vilagazi, but I think our problem is that we look at sectors versus, we look at like entities versus the sector. So we talk about Eskom versus talking about energy and the energy sector and how we're going to reform the energy sector. And when we talk about the actual sector, it becomes a lot more inclusive rather than talking about an entity that, yes, it's a huge majority, but we're trying to chip away from that. And all the resources, or at least a big chunk of the state resources over the past 10 years have gone to Eskom. But I think in looking at Eskom, we should look at the energy sector and allocate resources to the sector rather than to this entity, because there are other players beyond just Eskom. The other thing is that we also forget that state-owned entities are part of this oligopolistic nature of our economy, and so and they do crowd out smaller players, and we need to look into that and how to break them down. I think this is a great time to have that discussion now that we have the SOE panel or council, I think it is, that can look at all the 700 and odd SOEs and look at the efficiencies there, and where there are inefficiencies, then you can start opening up the sectors and involving other smaller players. I think there's a great opportunity there. The other one is definitely, SAA, Dr. Vilakazi mentioned it. I would have rather given, funded SMEs that 10.5 billion instead of SAA, because I think we all know the inevitable, what's going to happen. It's quite inevitable. And we allowed it to happen as South Africans. About, I think 162 billion rands has gone, in financial support has gone to 4 or 5 state-owned entities in the past 10 years. And that is a lot of money that could have gone elsewhere. And I think that it could have been a lot more impactful than what we've seen currently. The irony is that those 4 or 5 entities are still requiring funding, including Eskom and SAA.
Thank you very much, Dr. Leoka. So it's 162 billion rand, almost down the drain. Over 162 billion rand down the drain. In closing, let me thank our distinguished panelists for sharing their perspectives on the appropriate response for competition authorities to adequately respond to the challenges of COVID-19 crisis. I know we were slightly over time. I hope you found the session as informative as I did, and do enjoy the rest of the conference. And I believe tomorrow in the morning we have His Excellency Wamkele Mene, who is the first Secretary General of the African Continental Free Trade Area Secretariat. So you wouldn't want to miss that. So see you tomorrow at 9 a.m. But before we go, let's take it back to Songezo.
Thank you so much. Thank you so much, Deputy Commissioner. The reason why I put my face on video was that I was hoping you'd inadvertently come to me and ask me a question, at which point I would have just summarily ended the discussion altogether. But at the same time, how could I? I mean, how do I? And this is where imposter syndrome really kicked in. Dr. Leoka, Dr. Vilakazi, Dr. Kariuki, Acting Justice Manoya, and for good measure, the Deputy Commissioner who employs me. So I could only but sit and wait. But I think it is also true to the fact that the quality of the engagements that are the kind of questions that came through, and that the listeners have been here, have been engaging, and are still wanting more. Unfortunately, we simply cannot have more for want of time. Tomorrow does promise to be as humdinger as an engagement, as you've correctly referred to, Hadin. We've got the first ever Secretary General of the biggest trade agreement in the world. That's bigger than what NAFTA was. It's bigger than anything in Europe, certainly, and it's Africa's time to shine. Apparently it's now or never, so we will hear his thoughts on that. The panelists this evening in Kenya, Dr. Kariuki, so much, thank you indeed for your time. Dr. Leoka, thank you so much for always being the voice of reason and lending ear your time to the Commission. We thoroughly appreciate your thoughts. Alternate member of the Tribunal, CRED Executive Director, Dr. Vilagazi, a friend of the Commission. Sir, thank you so much for your time. Twice today, you've had to bet today and you didn't at all seem fatigued by it all. Norman, thank you so much. You're supposed to be in retirement. The next thing you go and take up a position on the bench. So much as for your contributions, continued contributions in this country's makeup. We do appreciate your time, sir. As of course is proper and protocol to say, Mr. Rashisusu, thank you so much for your time. Colleagues, let's meet then tomorrow, 9:30 sharp. All the technical challenges that could have been were not today. So well done to you as well for getting to grips with this technological age of having meetings and conferences across the continents as seamlessly as we have had them. Tomorrow is the second and final day. Be sure to tune in as the promise is more of what was today. Goodbye, everybody.
Hi.
Rita, is that you?
Yeah, I think the